Welcome to Monday Night Live, the weekly training that guides professionals to financial prosperity. Join our community and let's start building your wealth.
Good.
Welcome to the Monday Night Live tonight. We got a great guest, Bishoy Habib, who I met through the podcast interview. And what was interesting at the end of the interview, we were just chatting, which is typical. And he was asking about what I do and what we do. So I told him. So we've had further discussions, and it's a great person. I mean, he's not just an attorney, but he has a brokerage. He's an investor, and he's an author working on his publishing his first book. So keep an eye out for that. I mean, you've got somebody here that's obviously got a lot of talent and expertise, and the fact that he invests, I mean, this sure you fit right in. And tonight's subject, guys, is going to be on land trust, which is near and dear to our heart. So if we have time, we can broach other subjects. But let's go and get this started, Habib. If you don't mind, I keep calling you by your last name, Bishoy. I don't know where that came from. Bishoy, if you wouldn't mind.
Yeah, go
What's
ahead.
that?
No, I was
Yeah,
gonna say,
just
I feel like I'm on a sports team or something when you call me my last name, Habib.
there you
Habib.
go. That's right. Number 27.
Yeah.
But in any case, if you wouldn't mind, give everybody a little bit of background and how this whole thing occurred, because it's, a lot of us didn't start off wanting to be an investor or a real estate agent. We wanted to, be like an attorney, for example, or an astronaut. So if you could
Yeah.
take us down that road, and then we can jump into the presentation.
Well, I'm not smart enough to be an astronaut, but my journey in real estate began as a kid. My dad would drive me around to his rental properties. He was an investor, and I grew up in Orlando, Florida. So, that I kind of grew up in, and I think the thing that appealed to me about real estate, even as a 5 and 6 and 7 year old, was I always thought it was cool that my dad could just kind of make his own schedule and his own time, and do what he wanted to do when he wanted to do it, and not have a boss. And so, I grew up in that. I learned about it. I negotiated my first commercial lease when I was 15 years old, on my dad's property. And I don't know, looking back, how much I actually did, but at that time, I felt like I was, like the biggest negotiator in the world. So it was a nice high, and so I always wanted to do real estate. I went to law school, actually without the intention of practicing law. But when I got out of law school in 2012, the real estate market was, as we all know now, was pretty soft. But in hindsight, it was actually, we should have gobbled up everything in sight for the next 10 years. But it was tough to get a job. So I was like, all right, well, let me go practice law. Of course, real estate law. So I got a job in New York. I worked on big hotel deals up there. I was working with the largest hotel developer in Manhattan. We did acquisition, disposition, we did constructions, we did ground leases, we did JV agreements, syndications, everything you can imagine, which was the most tremendous experience from a kid from Orlando, Florida. After 2 years in that role, I came back down to Florida to be with my family, and I just continued on my trajectory. I did real estate deals. I did some finance law as well, doing huge finance deals, public finance and things like that. So airports and hospitals and schools. And so that taught me the nuances of financing. And then I just really honed in more on, real estate and lender representation. And that's kind of where my practice lies for the most part today. I've closed over 1,000 transactions as an attorney. I've done a ton of title, and represented every single party you can imagine in a transaction. How did I get my license as a realtor? Or as an agent? I got my license when I was 18 years old. I got it because my dad's like, you should get your license so when you do your own deals, and it was a good advice. I never represented anyone else. Well, technically I did a couple clients, but I wasn't really doing realtor work. I was doing attorney work. But I got my broker's license a few years ago. I was going to start a brokerage with a buddy of mine, and it didn't work out. But then I had the license, and then one of my top producing agent friends and clients came to me and said, "Hey, would you want to do this?" And so we talked about it for about a year, and then made it a reality. And so we started our own brokerage, Capstar Real Estate, in Tampa Bay, a little over a year ago now. It's been an interesting year to start a brokerage, but the market is where it is. We all have we're very confident it's going to bounce back. We're here in Tampa Bay, like I said, so things are just leveling off, but we have a lot of confidence in the market. But it's been a tremendous experience for me. Great insight into the realtor world, which I already had a lot of because I was closing a lot of deals on the title side and attorney side. But then you just see even more of the problems day to day. So that's my journey. That's how I got here. I opened my own law firm a year and a half ago. Legacy Legal, focused on helping investors maximize profits and limit liability. So I'm, responsive, investor friendly, and trustworthy are the three pillars that I built the law firm on. We handle real estate transactions, litigation, business transactions, and some estate planning as well. And we're based in Tampa, Florida. So that's my journey.
Nice. So, well, I'll tell you what, if you want to, you can go ahead and share your screen. We can start the PowerPoint. And so,
Okay.
guys, if when you have questions, just type them in the chat box. Okay. Or if you want to do the hand raise, there's a indicator you can do the hand raise down there. We'll stop. We'll strategically get those into to Bishoy. So, sound good?
All right.
Okay.
Can you guys see that screen?
Yep.
Okay, cool. Well, the topic today is land trusts. And we talk about land trusts, we talk about creative financing, we talk about kind of some nuanced things that you can do with land trusts. So it'll start off very beginner and it'll get a little bit more nuanced. If I lose you, just raise your hand or say something or just yell at me. Any of the three work. And if anyone's on social media, give me a follow. It's at Attorney Bishoy. That's Instagram, TikTok, YouTube, all of it. And I'm on LinkedIn as well. All right. So I hate presentations and big slides. There's two slides here that I'm going to kind of read off of, but it's really important to set the tone for why we use land trusts. All right. So the first one is Sarah, and it's a tale of two investors, right? So Sarah owns 6 rentals. She's got, what's that?
Oh, hang on. Sorry, we got it. Had to meet somebody.
Okay. So Sarah is the first investor. She owns 6 rentals. They're worth about $3 million, and they're held in 2 LLCs. One of the tenants tripped and fell on a sidewalk that she already had scheduled to repair. Minor injuries. It was like a bruised rib and a sprained wrist. And when that tenant that slipped and fell, they went to an attorney. The attorney did an asset search. They very easily found that Sarah owned these 2 LLCs. They tracked back the LLCs. They found that she owned 6 properties, and they ascertained that she was worth $3 million, despite the fact that there was minimal injuries and that she wasn't really negligent because she had it scheduled within a week of the issue arising. They still knew that she was worth something, so they pursued her aggressively. They dragged her through litigation for 2 years. They ran up her legal bill, and they ended up taking her to Miami-Dade County, a jury trial. And Miami-Dade here in Florida is a very aggressive county. You don't want to be litigating there. They ended up, after she spent $50,000 in legal fees, they ended up settling for $350,000. And by the way, these are based on true stories. The names have been changed. John is a client of mine who was smart. John owned 25 rental properties worth about $12 million, but he had set these up properly through land trusts. So on one of his lower end rentals, he was actually negligent. There was an issue. He ignored it. He didn't do anything. He didn't want to fix it because it was a cheaper property. He screwed up. It happens. He got 25 properties. Someone fell on the property, a tenant, and had serious injuries. Went to an attorney. The attorneys did the asset search. Guess what they found? They found that he had a homestead property, which is exempt here in Florida. You can't touch it. An 8-year-old Mercedes-Benz and a basic checking account. So despite $12 million in assets, the attorney assumed that John was worthless and broke. And so they settled for $70,000, which was within policy limits. John paid $0 out of pocket. And that is the power of the land trust. Right? So what is a land trust? A land trust is basically, you could think of it like an entity, right? So it's an agency relationship for holding real estate. The trustee holds title while the beneficiary, that's the true owner of the property, they control the property and they receive the benefits of the property. But the public doesn't know. And so when we talk about the big benefits of the land trust, I like to think as 5 of them, right? And there's 4 of them in all 49 states, and Florida has a bonus one that's kind of has an asterisk here. Number one, in every state, the biggest benefit to a land trust is the privacy. So you can't shoot what you can't see. It's like I always tell my clients. A lot of people ask me, well, Bishoy, I'm not really hiding anything. I'm not doing anything shady. So why do I need to hide what I own? To those people, I say you're missing the point, right? Would you be okay if your bank account information was all public record? If someone could just search your name and find what you owed, right, in the bank, what you had in the bank? And the answer is no. Everybody thinks that's absurd, but people don't think it's absurd to have all the property you own be public record, right? So just think about that for a minute. You have a bigger target on your back if people know that you're worth something. That's the way it goes, as in the example with Sarah and John. Hiding your name from the public record is always going to work in your favor when it comes to asset protection, right? So that's the first step in any asset protection plan is privacy. Anonymity is another word. We'll skip number 2 here. Number 3, estate planning. So anybody that's gone through a probate process, I have 2 schools of people when I say the word probate. One group doesn't know what it means, and the other group cringes when they hear it. Why do they cringe? Because probate is a painful process. That's the only way I can explain it. And you would only know if you've been through it. It's the court-ordered process that you take someone's belongings or assets and put them, hire attorneys because you have to, and you have to go through court. And the court has to say, well, Mr. Smith died, and yes, we agree that his daughter should get this, and his son should get this, and his ex-wife should get this, and his current wife should get this. But if there's anyone that's owed money, they should get it first. That's probate in a nutshell. And it could take 6 months, 9 months, 12 months, more than a year, depending on how many assets and how many beneficiaries there are or heirs there are. We can avoid all of that by using a land trust. So the way it works is you dictate in the land trust agreement, which we'll talk about, who gets the property when you die, and it automatically goes to that person. There's no need for probate. There's no need for court. There's no need for attorneys. You just show a death certificate and that person gets the property. You don't even have to record anything on public record. It's amazing. The next benefit is no reporting requirements. I know everybody on this call because you're on Gary's meeting, so you must be very sharp. You must be very smart. I know you guys all have your BOI information filed with FinCEN, the Department of State. That's the new regulation that takes effect January 1st. So you got about 35 days. And the federal government says if you don't have that information in there, they can throw you in jail. And I'm not making that up. That's actually the law. But you want to have all that stuff reported for your LLCs, your corporations, etc. But you don't have to report anything for land trust, at least not as of today. So no reporting requirements to the state, no reporting requirements to FinCEN, no reporting requirements to the federal government, and no annual fees. Now, limited liability is only inclusive in Florida. That's the only state out of 50 states where land trusts have limited liability. If you're active in Florida, as I am, I'm here in Tampa. So what you need to understand is that if someone slips and falls in your property and it's owned in a land trust in Florida, you have the same limited liability protections that you do in an LLC. It's a beautiful thing. It's a win-win situation here in Florida. We have the best land trust in the entire country here in Florida. So if you're here, you absolutely need to look into getting one because it's better than an LLC for that reason. The most common example that people like to talk about land trust, and by people, I mean, land trust nerds like myself, is Disney. Disney's the poster child. So what happened with Disney was they were in California in, I don't know, the 1950s or 40s, whenever they opened Disneyland, not Disney World, Disneyland out in California. Well, what happened? They got big, they blew up, they became popular, and they kind of got landlocked because nobody wanted to sell them land at a reasonable price because they were Disney. So everyone started jacking up the price, and that's why that park in California is relatively small. So what happened, Walt Disney, being the savvy businessman that he was, decided to use land trusts in order to build an empire on the East Coast in Orlando. So using land trust, he quietly and secretly acquired more than 27,000 acres by purchasing them in land trusts where nobody knew who the true buyer was, from these farmers and so on. Well, before people knew it, once they looked up, Disney owned 27,000 acres, and nobody had any idea who they had sold the properties to. If he had bought these in a traditional way, there's no way Disney would have existed today, Disney World. And that's the power of the land trust. We got 3 key parties in a land trust. 2 of them you're going to see in every land trust, and the third one you may or may not. So it starts with the trustee. The trustee is the one whose name is going to appear on title. The trustee is the one who appears to have control of the trust, right? In reality, the trustee, when I set up my trust, is a figurehead, okay? So they have no actual authority. When I set up my land trust, they just sign where the beneficiary tells them to sign, okay? So, and this is a question I get a lot, and people get nervous and they get scared to have a third-party trustee on there and say, what if they steal my property? Well, they don't have the right to do that. Anyone can forge a deed, right? And it could be valid up until they get caught. And so that's just a risk of all real estate. But the trustee has no legal authority to sign without your permission in the land trusts. And the way that I draft them, which is the common way to draft them, the trustee is a figurehead to protect you. Now, the beneficiary, number 2 here, that's the individual or company or whatever it is that actually owns the title, the beneficial interest in the property, right? So they're the ones who control it. They collect the rent. They manage it. They decide to sell, refinance, whatever. So the beneficiary would be you in this situation, right? Whoever actually owns the property. Now, the third one is a power of direction. It doesn't get talked about a lot, but it can be a game changer. And the reason being, you want to use a power of direction where there's multiple beneficiaries, right? And so there's 2 situations we see this a lot: when there's a lot of siblings, number 1, or when it's a business relationship and there's 2, 3, 4 parties. The trustee, and I'm telling you this from experience, the trustee doesn't want to deal with 6 siblings in 6 different time zones telling him 6 different things. The trustee doesn't want to deal with a partnership where every partner has their opinion. The trustee needs to and wants to just have one person, one point of contact that says, this is what we're doing, and can rely on that. It makes it easier for you as a beneficiary, and it makes it easier for me as a trustee. The power of direction can be a beneficiary, but it doesn't have to be. It could be a third party. Okay. When we talk about the land trust agreement, do I have any questions? I hear somebody.
Yeah, if you guys have questions, feel free to do a hand raise or type in the chat box. Looks like Bishoy, looks like PF just typed something in the chat box. Is
the beneficiary a public record? No. Beneficiary is not a public record. And that's the exact point. You stay hidden as the owner of the property. You stay hidden. And that's the key. Great question. So let's talk about the land trust agreement. There's not too much to talk about. It's pretty straightforward. The land trust agreement, you could think of it as exactly the same thing as an operating agreement would be for an LLC. That's all it is. It lays out the rules, the requirements. What does the trustee have to do? What liabilities does everyone have? What the beneficiaries can and can't do? And if there's a power of direction given, who has it, and so forth. I give you an example. I got a call today because this can include a lot more than just what I told you. So I got a call today. Is a guy who wants to JV. Actually, I did a presentation on land trust last week. So he called me on it. He's like, that was awesome. I want some land trusts. I'm doing JVs. He teaches courses, just like you, Gary. He teaches courses to investors. And now his students want to JV with him on fix and flips. He's like, let's do them in land trust. I like the way you set it up. How do I set it up so I'm protected? And so what I came up with, I said, I'll create the land trust agreement. And in there, I'm going to put all the terms in there. And so I'm going to protect you so that you have the power of direction. You can decide when to sell the properties, right? Because you have the experience with these, not the students. So you should be in charge of all these rules. And then, of course, we'll lay out, the waterfall structure. And I mean, it's a 50-50 in this case. But the point is, we're going to lay it all out in the land trust agreement. So it's going to be nice, clean, tidy, not off the record, but, it's going to make perfect sense for all the parties. And so that's what a land trust agreement entails.
Okay.
So this is some basic stuff on land trusts. Now, when we sell property in a land trust, there's two ways we can do it. Okay. The first way is the way that you know about and everyone knows about. You could deed the property over. So the land trust sells it to the buyer. Okay. And it's a deed and it's recorded and it's easy peasy. The other way, and this is kind of a segue into the more nuanced part, right? Because that's land trust 101, what we just did. And now we're kind of slowly going into the nuances. The second way to transfer to sell the land trust or the property in land trust is to assign the beneficial interest. Now, to recap, the beneficial interest is the actual ownership in the land trust, right? That's what actually who gets the benefit of it. So rather than record a deed and the property transfers on public record, we assign the beneficial interest, which is not real property, it's personal property. And there's a distinction, and we'll talk more about that in a minute, but there's a big legal distinction because the way you foreclose on real property and the way you foreclose on personal property are very different. They're treated very different because they are very different, right? So your car would be personal property, your home would be real property, okay? So couple common mistakes I like to point out because I see these all the time. Two big ones. Number one, when people DIY their land trust, right? When people, I don't know, get a form from their buddy and try to duplicate it. So two things. Number one, don't name yourself as the trustee. That's a inclination that a lot of people have, and it's wrong. And the reason it's wrong is because if you name yourself the trustee, you void the biggest benefit of the trust, of the land trust, which is the anonymity aspect, because the trustee's name is public record. So don't name yourself as trustee. Number two, when you deed the property into the trust, like when the trust buys the property or transfers in, you have to put certain language on there. Otherwise, you're not getting all the benefits of the land trust. So two key points that you want to be careful of. Now, people always ask me about operating the land trust. So, it just really depends on your situation. But the point is, the trustee really has nothing to do with the management or the operation of the property, in most cases. So, like if I act as trustee for my clients, I have nothing to do with the rent. I have nothing to do with the taxes. I have nothing to do with anything except sign on this line because, we're refinancing, right? Or sign these loan docs or we're selling, right? Other than that, I stay out of it. If they need me to sign a lease, we could set it up so that they sign the lease. A lot of my clients have third-party management companies that they create. So that third-party management company manages the property. So again, I say it really depends. I think the biggest thing I want to point out is that the trustee doesn't actually have anything to do with the management of the property. Okay. All right. Now let's talk about nothing in the chat box. Now let's talk about creative financing. Okay. How many people here, by a raise
Hi, I
of
just want
hand,
to take a moment
have
to thank
ever
you for
done or
watching a
heard of a
recording of
subject
the
to
Monday Night Live
transaction?
class. Hope you're getting a lot out of it. I'm sure you will. I wanted to let you know that, you can come to Monday Night Live whenever you want, but you can also participate more with the team. Why don't you set up a call with me, a one-on-one strategy call? I can go over everything with you, show you everything that we have to offer. For example, did you know that on our team, not only do you get your leads, we actually give you your own account on our lead gen system. So this puts you in control. You're not waiting on somebody to hand you leads. You get to pick the ones you want. Okay. Huge difference. We have 21 of our own proprietary marketing campaigns. They're all copyright protected. We're the only ones that can use them. Okay. The coaching is absolutely one-on-one. We got 3 coaches. We even have a 4th success coach that we have access to. Okay. One of left fewer than 100 in the world. Okay. One-on-one coaching. Right now the big problem is volume. We need more transactions. We need more inventory. I get it. Well, we know how to get it. Our team actually outproduces the national average by more than 2 to 1. So if you're struggling, don't do that anymore. If you're a solo agent, if you're a team, let's just talk. Smart entrepreneurs are always open to discussion. Learn what we have to offer, and then you can make an informed decision about staying where you are or moving on. You've got to decide, if you're not where you want to be, you've got to take action to get where you want to be. Let's see how we can help you do that. I look forward to talking to you. Click on the link, set up a call. And by the way, I'll see you on the next Monday Night Live.
Is anybody raising their hands? I can't even tell.
Yeah, it's
Okay.
probably most people here.
Okay.
It's
Awesome.
yeah,
Awesome.
yeah.
Awesome. So some of this stuff will make sense. The sub twos, I'll just high level for those who don't know, it's okay. A subject to transaction is just where you buy a property and you leave the mortgage in place after closing. So we don't pay off the lender. And the reason we would do that is because the lender has a loan that's lower than the current interest rate today that the buyer could get. So we've seen it. The reason we've been seeing a ton of these is because in 2020, 21, rates were historically low, the lowest they've ever been, 3%, 2.5%, 3.5%. And now obviously they're much higher. So if you're a buyer, you can make that the numbers work at 3.5%. You can't make them work at 6.5% or 7%. So people would leave the loans in place. And so in a legal sense, that's called subject to. You're buying the property subject to the mortgage. So they're called sub twos. So the idea is there is risk to both parties with a subject to transaction, right? I always say the parties are, it's one of the few transactions where the parties are married after closing. Why? Because the buyer has to trust that the seller isn't going to do anything to screw up the loan and have it called due, right? We all have heard about the due on sale clause in the mortgage where the lender can call the loan due because it's been transferred. So the buyer has the risk that the seller or someone's going to alert the lender and call the loan due. The seller has the risk that the buyer is not going to pay the lender and ruin the seller's credit, and potentially the lender can go after the seller for a deficiency judgment, meaning that they have to come out of pocket for money. So even after closing, the parties have to play nice, right? We want to mitigate the risk as much as possible with the subject to transactions, and that's why we use a land trust. So instead of just deeding it from person A to person B or person A to this LLC or, this entity, by putting in a land trust, we kind of mask what we're actually doing so that the lender has a harder time deciding. Because the biggest thing we're trying to prevent in a subject to is the lender calling the loan due, because that blows up the whole sub two and then there's no deal. So when we do this, there's a couple steps. So first we move the property into a land trust, right before the transaction closes. Then what we do is the seller transfers a beneficial interest in the land trust to the buyer, and then we close like that. But there's a way to do it that I structure where it's a conditional beneficial interest. And now this is where the real property versus personal property comes into play. Because the way that we could set this up is that if the seller or if the buyer defaults, the seller can go back and get those beneficial interests very quickly. If the seller had to foreclose, or if anyone had to foreclose, you guys know how long foreclosures take. At least in Florida, we're a foreclosure state. So the foreclosures could take years. I mean, literally, it's not going to be done for years, right? Because we actually have foreclosures from 2011 still on the docket. This is true. This is a fact. You could look them up. So this is a much more streamlined way to do the creative financing, the sub two deals. And that's why I say here that it protects both parties. Why do we even do all this with the land trust? So if the lender were to find out about this, right, and they caught on, which again, they may be, but they may not. I mean, it's kind of hard to see what's going on. But if they found out somehow, we would then invoke the Garn-St. Germain Act of 1980. It was a law implemented by Ronald Reagan, right? Reaganomics, when he wanted to encourage investors to estate plan. And so part of what the Garn-St. Germain Act of 1980 states is that if you move your property from your name into a revocable trust, which a land trust is a revocable trust, that the lender cannot invoke the due on sale clause. And so when we say that, we push back and the lenders kind of back down. Now, a couple things I like to be very clear on with the sub two transactions. People get a little bit queasy with these and they think that they're doing something illegal. And I just want to be clear, it's not illegal what you're doing, right? If you do a sub two transaction, all you're doing as a seller, you are breaching the contract that you have with your lender. It's a civil matter. It's not criminal. It's not illegal. It's just like if me and you made an agreement and you breached the agreement. And what's the penalty if you breach the agreement with the lender? They call the loan due. And that's it. That's the end of that. So again, I mean, I get people who get a little bit weird about it, and that's fine if you're not comfortable with it, but you just have to understand that it's a mortgage and a note and different loan docs you signed. And if you're the seller and you're doing the sub two, you're technically in default of those if you're doing a transaction like this. But again, the worst that could happen is they call the loan due. So we mitigate that risk as much as we can using land trust and other kind of methods within the land trust. And then the pro tip I have is if you want to name the property, if you want to name the land trust, either after the property or even after the seller, sometimes I've done that as well. So it disguises it a little bit more. Kind of a deep concept. So if anybody has any questions, especially if you're familiar with sub twos, happy to answer those.
Well, I think something that's kind of new to me is I didn't realize that I guess you can put certain language in so that if the buyer starts not making the payments, there's a pathway for the seller to regain control. Is that right? Or beneficial rights?
Yeah. So I have represented both sides in the sub twos. I represent buyers, I represent sellers. And so I've learned what the risks are to both sides. And there are quite a few risks to both sides. I mean, there are risky transactions, especially like if you're a buyer and you go in and they call the loan due and you just got to come up with like 600,000-700,000 overnight, So I've thought through all the risks, and the conditional assignment of beneficial interest protects the seller, really protects the seller. And I got to tell you something. I try to only work with ethical investors. You can never really tell up front, but the people that I work with, I've had good experiences with my clients, and like they started using that conditional assignment of beneficial interest to their advantage. You know how? They explain to the seller, look, you sign this document, I sign this document. You could take this back if I don't pay you for 60 days. It's that simple. And I've had buyers and clients of mine who are buyers in sub twos say, hey, look, here's the seller's number. Can you call them and explain how this works, how easy this is to them? And I do. And it closes the deal a lot of times. And it makes me feel good that my buyers are promoting this, because it makes me understand that they're not planning to default on these loans. But it absolutely can be a selling point if you're a buyer and say, look, like the way we're structuring this is how it's going to work. Right. And so it works out well. I've seen it. I've had it happen where we did have to take the property back through the beneficial interest. We figured it all out, and everybody's fine now, right? So I've seen it come into play. It definitely could come into play. The main thing is if the buyer and seller will cooperate with each other in some form or another, we can usually reach a resolution. It's when the lender dictates everything that it's hard for everybody to win at that point. Kurt has a question here. Have a situation right now on a home that I'm buying on a contract for deed, land contract. But now I'm wondering if a sub two deal would be better, especially if I want to buy and hold. Can you comment on that? Yeah, I mean, it depends. It depends on what you want to do. The contract for deeds, I don't love those on the buy side, because you're just paying into something that you don't own. So you could be paying for a long time, and then if you miss a payment, or obviously depends on the terms of the contract for deed, but if you miss a payment or two payments, then you just like lose out on all that equity, right? That's not fair to me. The sub two might be a better option for you in the sense that you will have title to the property, and then at least they'll take it back, but you can control the property in full. So that's an option. I also could recommend, the seller financing if they'll go for that. Obviously, I'm assuming you tried that and they didn't. So, lease options are okay as well, because at least then you have a leasehold interest in the property. I obviously don't know how yours is set up, Kurt. I don't know, does that answer your question? And I don't know if we can unmute Kurt.
I think, am I unmuted?
We could hear you. Yeah, I can hear you.
Okay. Yeah, I need to decide if I want to buy and hold it. or flip it. I guess if I flip it, then the contract for deed probably is okay for a short period of time. But like you said, you don't control the property. You don't, you're just making payments. So that was my concern. If I wanted to buy and hold it, would a subject to be better?
I think it's better just baseline because again, I mean, you can control the property. I would not feel comfortable paying for a property month after month where I didn't really fully control it. And it's not like this in every state, but like in Florida, it's a mortgage. So we close on it, I own it, and then there's a mortgage. They have to take the property back from me. And so if things go sideways, I have time to figure out what to do. I have exit strategies. So we want to create as many of those exit strategies as we can. And if I'm representing a buyer, I'm going to put like in a sub two the way to just explain it, I'm going to put all these different hoops that the seller has to jump through before they actually take the beneficial interest back. Notices, written notices, delivered this way, this many days to respond, this many days to cure, whatever, right? If I'm representing the seller, I'm going to do the opposite. I'm going to say, you got, 30 days from the date that you were supposed to pay, and that's that. So you got to structure it in the way that, benefits you. Obviously, that's the whole point. But I think that the contract for deed is kind of like the lowest level because I don't know how yours is structured, but you don't own anything, right? So you're kind of like paying all this money into something and you hope that you don't have a disaster or something doesn't happen to you. And then you just kind of miss out on payments for a month and lose all that equity. So that's the risk you run.
Okay. Thank you.
Hey, Bishoy, on the bank's right to call on a note in a trust, and this may be something I heard, it could be incorrect. Because of the Garn St. Germain Act, I think they're precluded from calling in the note, except for the case where it's not being paid on. But again, I could be completely wet there, and I don't know. I don't want people to rely on that because I've told them that before. But is there more specifics on that? What the bank can and can't do with it?
Well, yeah, okay, definitely. So I probably should have been more clear, Gary. I think thank you for pointing that out. That doesn't mean you don't pay your mortgage and they can't call it due. That means that okay, so I probably should have prefaced it. So if you transfer an interest in the property that has a loan on it, they can call it due. So if I deed the property to Gary, my lender could call the loan due. That's every loan document in the world has a due on sale clause for transfer, for assignability. If I transfer a beneficial interest in the property, right? If the loan docs are written well, right? If it's my client, I wrote the loan docs, it's going to say any assignment of beneficial interest. So if I own an LLC and I sell my shares to Gary, right, or my membership units, that's also considered something that the loan could be called due for, right? So the lenders aren't dumb. They know what's going on, right? So by the same token, this just prevents the bank or the lender from calling it due for transferring the property, not for defaulting for another reason, like not paying the loan. You don't pay the loan, you got a whole other set of issues. I can't help you there. Actually, I can because I do loan modifications, but that's a different topic.
There you go.
Yeah. So, but yeah, that's a different talk. So, yeah, but does that help?
And yeah, thank you very much. I appreciate that.
Okay, cool. All right, let's get even deeper in the weeds. Equity stripping. What is equity stripping? Equity stripping is when it's a form of asset protection where you have a property and you have equity in it and you strip the equity away so that creditors, when they come to look you up, it appears as though you don't have equity in the property, and therefore it pushes them away from coming after you for frivolous lawsuits. So basically the way it would work, Gary, because he's a big bad investor, he's got, a bunch of properties free and clear, right? If Gary were to get in a car accident and hit me and, my back hurt, I'm going to do an asset search. And what am I going to find? If the properties are not in a land trust, I'm going to find that Gary or Gary's LLC owns all these properties free and clear. Well, that's 20 properties and that's $500,000 each. So, that's $10 million, right? Now, what if I did that same asset search and those properties all had 90 to 95% LTV loans on them? How much equity does Gary have at that point? A couple 100,000 between all 20 properties, right? Am I going to go after Gary? I'm less likely, I'm less inclined, right? And that's kind of the point. So what we do is we put the properties in a land trust so nobody knows who owns them, right? Step one. Step two is we then put a loan, paper a loan and put a mortgage against the property, right? For up to 95% LTV, 90, 95. You got to keep it realistic. You can't do 100%. And that loan is a loan to itself. Now, so far we haven't done anything wrong. It's a credible loan. It could just be a line of credit, which is how we actually set it up. So you could draw on it at any time, right? But it's not actually a loan. It's a line of credit. So you don't actually have to have the money exchanged because it's a line. Mm-hmm. So that's how you strip the equity. Now the same lender comes, they see that, the house is worth 500, but it's loaned up to $480,000. It's not even worth their time to try to get that 20,000 out, right? So that's the idea. Couple very important nuances. If you ever get into a litigation and if the court ever asks about this stuff, you absolutely have to just say, yeah, that's my loan, right? That's my company that made the loan, right? It doesn't actually have any money drawn on it, right? Or whatever they ask you. That's only if the court orders you to disclose what's going on. Now, the whole idea is you're not saying anything. This is all public record. So it kind of speaks for itself. And that's the idea of equity stripping, right? It's the appearance of, I just kind of think of it like a porcupine, when porcupines in the wild and they just kind of they see a lion come in and they just kind of, do their thing. Like the lion's not really interested. It can't get to the meat, right? So that's kind of what we're doing here. You just you're making yourself unappealing. So someone moves on. You always want to make yourself look broke. That's the key to asset protection. So that's equity stripping. What do we think?
I like it.
Yeah. There are some windows.
So it's a line of credit that you actually could use,
Yeah. It is 100%. People are telling me that there's blocks on the PowerPoint. I don't see them on my end. So I don't know how to get them off.
Oh, one just disappeared. Big square one in the middle.
Big one you took off.
Is it off now?
There's just a smaller one down below, but
it's like a rectangle, sort of a bar towards the bottom.
How about now?
It might just be background. Oh, it disappeared. There you go. You know what it was?
Perfect.
It was background color. Yeah.
Yeah. Perfect. All right. So when we talk about land trusts, the cool part about them, I like things to be simple. And the thing is, I'm not a tax guy. I'm not a tax expert. I'm not a tax attorney. So I love land trusts because there's no tax ramifications to them, right? There's no EIN number. You cannot get an EIN number with the land trust because it's a revocable trust. You can do a 1031 exchange. You do not have to file taxes for it. And it's a pass-through or flow-through entity. So whoever actually owns the beneficial interest in the property or in the land trust, that's who would report taxes and get depreciation and all that. So taxes, it's completely neutral. No upside, no downside, which is nice. All right. I won't beat this slide too much, but the idea is you always have to name the trustee in a lawsuit. So you as the beneficiary should not be named in a lawsuit, like personally named. Your trustee should. So a lot of people screw this up, even attorneys. They don't know how to name the land trust in a lawsuit, and so it ends up causing them delays, which buys you some time as a landlord or land trust beneficiary or whatever. So just something to know. Again, nothing too crazy here. Yeah, so the couple things that I would say about the land trust to keep an eye on is, if I had to nitpick with them, it's number one, you got to make sure your lender, if you're purchasing, make sure your lender is familiar with land trust. A lot of them are, but some of them aren't. If you're an investor, you have your investor-friendly lenders. They're going to be okay with the land trust. if you go to Chase or BOA, they would probably prefer you move it into a revocable trust, or a living trust, which is the cousin of a land trust. Just a little bit different, but a lot of similarities. But banks are just way more comfortable with those for whatever reason, because, they got to check their boxes. So you just want to make sure if you're buying that they're okay with that. And then this is just a Florida slide here, but in Florida, you can't put your homestead in a land trust, because if you do, you forfeit the anonymity or you forfeit the tax benefits, but you can't have both. It doesn't really matter, because homestead properties in Florida are exempt from any sort of creditor lawsuits or judgments. So at the end of the day, it's not the biggest deal. But I like to point that out because I got a lot of people ask me about putting their homestead property in a land trust.
Okay.
So it's just a general slide. So I mean, that's kind of the gist of it right there. I will really like to open the floor to questions, and there's my contact info. There's my social media. Give me a follow if you're on there, and scan the QR code, get on our mailing list. But that's the gist of it. I don't know if I put everyone to sleep or if everyone has too many questions, or how do we feel?
But I do have one just my math brain kicking in here. So when you sell the beneficial rights to a trust as opposed to selling the underlying entity, um, that's personal property. Is there an outlet for, you know, I don't want to, how do I want to say this? Um, Legally, at least postponing the tax burden on that. Like if I put that in another, like a personal trust, or as soon as you sell beneficial rights, even as personal property, is that like a taxable event? You just report it on your 1040. I mean, I haven't done it. That's why I'm asking. But my math brain was kicking as you were saying that. I was thinking there might be some additional benefits here. You know?
Yeah, yeah. I mean, it's all self-reported at that point, right? Because nobody's really tracking it back. I mean, it goes through the title company, but
Mhm.
yes, you should pretty much report it tax-wise the same way. It just flows through whoever the beneficial interest is.
Yeah. But if you move proceeds, let's say, I guess there's two questions here. So number one, if we sell the property in the trust and those proceeds stay in the trust, um, to then be transferred to other trusts. I'm not like personally taking possession of the funds, the proceeds. They're not going in my personal account. They're just going direct from the land trust to another type of trust. Does that, as long as it stays in that structure, I guess that's called the corpus. Um, it's not like the IRS is looking for it. There's nothing there to report because you didn't actually take the money out. You know, I know
Right.
that's beyond the scope of the class, and I'm just it's just stuff I've read about other types of trusts before, and I was just wondering if it applies to these also. You know,
I don't want to I don't know about the tax. I don't want to
okay,
speak on that. I'm not sure on, I guess I don't really understand what the question is, but I'm not the tax guy either.
yeah, well, that's okay. Really, what it comes down to, if I can not actually take possession of the money, like it doesn't come out of the trust and into my own personal account, there's probably a way I can kick the can down the street legally, tax wise, like by putting it in another trust or acquiring another asset inside that trust with those same proceeds. Um, I don't know. I know my tax attorney. I've been with him for a long, long time, and this stuff is just, you know, he has another person that he farms that stuff out to. Um,
Right.
so, but of course, being entrepreneurs, we're always looking for that. How can we use the tax code as our friend and you know, at least postpone the tax burden, as much
Yep.
as possible. So,
Yep. So, Kevin asked, what are the steps to making a land trust? So, we would get the information from the client. So trustee's name, beneficiary's name or names, successor beneficiaries, what happens when they die, the beneficiaries die, who gets it, property address that you're going to be buying, all the information that, we would want to put any special provisions in there. Once we gather that, we create the land trust agreement. Once we create the land trust agreement, all the parties have to sign. And then once all the parties sign, we then transfer the property into the land trust. And that's it. It's that simple. I should have said this earlier. Land trust can only do one thing. They only serve one purpose, holding real estate. They cannot hold any other asset. They cannot do anything else.
Yeah. So when the property goes into the trust, is that an actual recording, like a deed recording?
Yes, it is. And it's a special kind of deed. It's a trustee's deed. So you have to make sure you use the right kind of deed and don't just use a regular quitclaim or warranty deed, because that is not going to give you the benefits of the land trust that you want.
Yeah. And something else I've seen I don't know if this is true in every state. Most states are very aggressive on collecting transfer taxes, but
Yeah.
some of the states I know, they actually don't collect a transfer tax when you move a property into a trust, which is kind of neat,
Yeah, it depends on, like here in Florida, if I sell you the beneficial interest, we should be paying dock stamps on that.
Okay.
But I mean, if I'm just moving it to my own, that's different. If it's in my name and I'm moving it into a trust that I own, you wouldn't know taxes on that. But if
Awesome.
if I'm selling what's inside the trust to you, we should be paying taxes on that.
Yeah, correct. Yeah.
I had a
The thing is,
question.
yeah, go ahead,
Sorry,
Chitra.
Gary. I have a question for Bishoy. So I'm in the middle of a transaction. The party A owns a property which is worth, say, around 20 million. She wants to bring in a partner because she can't handle the loan anymore. It's too high. So she wants to bring in a partner at 10 million on the loan. Would you advise that the whole thing be restructured through a land trust, or should he just come in as an equity partner on the loan? I mean, this is just an arbitrary question. You don't have to answer it.
So when you say they're going to come in as an equity partner, are they going to buy in and then be responsible for 10 million of the debt, or what?
Yes, 10 million of the debt.
How is it currently held, the title?
In an LLC.
You could, I mean, they're not buying it subject to, so you could just have that owner, assuming it's a single purpose entity, LLC, meaning that LLC doesn't own anything else. It may just be easier to assign 50% of the membership units to the new buyer. I mean, if you want to talk about simplicity, that's going to be the easiest thing. Now, if you have other reasons you want to move it into a land trust, then could work, but it's more likely to trigger a due on sale if they move it out of the LLC than they just leave it in there.
Right. Thanks so much. Thank you.
Yeah. Yep. And then I think there was one question here. What do we have? Oh, we answered that. Okay.
Yeah. Any more questions, guys? We're getting close to 8 o'clock hour. I'll stay on for a few minutes afterwards too, if anybody has any other subjects to discuss or questions to ask. But
Bishoy, there are some gurus out there teaching some newbies how to do sub-2 transactions, and they're not actually the ones that are going to be the beneficial interest holders in the trust. They're wholesaling. What are your thoughts on people who do that?
To wholesale sub-2s?
Yeah.
Well, I'm assuming they're making their money on an assignment on the front end, right?
Yep. So they're making the agreement with the seller, and then they're assigning that to somebody else who is previously unbeknownst to the seller.
I mean, yeah, I don't have a problem with the wholesaler doing it if they're disclosing what they're doing. The problem with wholesaling, and I do wholesaling on the side, and I do novation deals on the side, and I do subject to deals on the side, is disclosure. I mean, that's all it is. I just literally recorded a video this morning, and all I was talking about was like disclosure is the key to there's not, you could do anything you want if you're telling people what you want. Not literally, but you know what I'm saying. So I feel like if they're transparent with the seller and say, look, here's what's going to happen. I'm going to find someone to take this property off your back, because the reason people do sub twos is because they're burdened by the monthly payments and they're not living there. It's a second home. They can't afford it. So they almost don't care as long as they feel like it's someone that can actually make the payments. And then it's on the wholesaler to find someone who's actually going to be able to make the payments. Could be a conflict of interest, though. You're absolutely right. I mean, it's a very good question.
My first question to those wholesalers is, why don't you just finish the deal, do it yourself? So
Right. They'd rather make $5,000 or $10,000.
yeah, well, they obviously need that money now, and
Yeah.
maybe they're not ready to take on the added financial responsibility. Follow-up question. I've heard through my network of people that play in this realm that Wells Fargo is actually researching transfers into trusts and starting to exercise the due on sale clauses. Have you heard any wind of that?
I have. So not specifically with Wells Fargo, but I'll tell you guys a crazy horror story here as we kind of wrap up the call, something to keep you up at night. No, I always thought the due on sale clause was kind of like a scare tactic, because you didn't really see it called, you didn't see loans called too often in the past. The problem is when a bank or financial institution lends money at 3% and now rates are at 8%, they're just chomping at the bit to figure out how to get that money called back. And so there was a bank the size of Wells Fargo. I'm not going to drop their name on this call right now publicly, but they're on that same scale. Everybody on the call knows them. And literally someone that worked there told me this, right? So this isn't like hearsay. They had all these people on payroll, all these LOs, these loan officers, and they're still on payroll. They're still getting paid. They're not independent contractors. So they got to do something. Well, they're not making loans. Who was applying for loans in 2022? Nobody. Who was applying in 23? Nobody. So what were these people doing? They were reading the covenants, the financial covenants for all the loans that they had made and trying to put people in default in order to call the loans due, in order to recycle that money at 8% instead of 3%. And I had a client who was a church who had millions of dollars of a loan and millions of dollars in the bank with said institution, financial institution, never been late, never been delinquent, never had an issue, just like a perfect borrower. And they tried to call the loan due because one of the guarantors died. It was the most outrageous thing you ever heard in your life. And it did not end well for the bank. They didn't put it in default, but the fact that they had the gall to even go there tells me that what you're saying, Eric, is 1,000% accurate. And I don't have any doubts about that. Those institutions are trying to get their money, out of 3% and into 7 and 8%. And I mean, that's just the name of the game, So you're better off. There's no foolproof plan. Nothing is foolproof. Nothing I've said today is bulletproof. Nothing anybody tells you is bulletproof. And if anybody tells you it's bulletproof, it's BS. But what I tell you is to create different hurdles or barriers from people getting to you, number one, on asset protection, and to prevent the deal from blowing up on the creative financing deals. So these steps we take are precautions that keep us a little bit safer. At the end of the day, it's all a risk, but that's what business is.
Yeah. One of the keys is when it comes back to business, guys, remember fundamentally, just like in a sporting event or in military battle, just in the same true as businesses, you have to play offense and defense. You have to play offense to score points, make money. And boy, you better sure have a defensive game plan in place, because if you don't, it can be already taken away. The thing with defense is if you do it correctly, it's not something you have to like actively monitor every day like offense. Defense, when you have someone like Bishoy working on your behalf, documenting these trusts for you the right way, so you record a trustee deed and not a traditional deed when you move the property in a trust, things like that. You know, things that attorneys would know like the inside of their eyelids, and most other people who are not attorneys probably don't know all these nuances. You have to be careful. You have to play defense And this was a big part of it. So in the beginning, I started using LLCs way back in the 90s, and they were still pretty new. And everybody's like, yeah, use an LLC, man. And they're great. They serve a purpose, but trust has much stronger protections in place for you than an LLC ever will. I think. I mean, am I right, Bishoy? Like a trust is just, it's a whole different, you know.
I will. I'm licensed in Florida, so I will tell you, Florida trusts are the best asset protection tool, better than an LLC or anything like that. Not every state has the same precautions, so it's state by state. Not every state has laws on land trusts, so you have to. And I should have said this earlier in the call, so I'm glad you brought it up. It's not universal. It's not all 50 states don't have the same rules on land trusts. They don't all have the same protections. They don't all have the same laws. The things that I've shared today are pretty universal. Anonymity, the way it all works, the parties and all that. That's all consistent. But what's not consistent is every state has its own rules and regulations on them. In Florida, Gary, where I practice, 100% the land trust is a better tool than the LLC. And
Yeah.
you brought up a point. I took it out of my presentation before we got on, but
Hmm.
LLCs were not even around until I think they were around in the 80s. They got cool in the 90s. Like Gary said, land trusts have been around since the 60s, at least in the beginning, like Florida, Chicago, or Illinois. So these are like predating. These are and if you really want to go back, trusts date back to like England in the 1400s and 1500s. So this is like a tried and true tool that's been around for 500 years to protect people's estates and assets and pass it from generation to generation. The LLC is a cool young kid on the block relative to the trust and to the land trust. So just think about that. It's a tool that the ultra wealthy have been using for years to safeguard their assets. And I think it's time that we get the secret out there, you know?
Yeah. Well, I think this is my history brain kicking in. I think the first land trusts in the states were in Illinois, and some
Yes,
states, like you
Illinois.
said, don't even have them.
Illinois. That's why we call it the Illinois Land Trust.
Exactly. Yeah.
Yep.
But I tell you what, man, the if you think about, every 4 years we watch a general election, presidential election, and then every 2 years we see the House of Representatives. If you think about it, in any political campaign, and I want you to raise your hand if the answer is yes to this, have you ever heard any politician say, and man, we're going to go after those trusts? I've never heard it in my entire life of voting. Not one politician's ever said, hey, we're going after those trusts. You know why?
Because that's
Because
all
they
their
use
donors.
that's right.
Yeah.
So I just think, if you always hear one party particularly going after we're going to go after those businesses, we're going to make those businesses pay more, and we're going to, shut this down and shut that down. None of them have ever said anything like that about trust. So, take it to heart. And I think, I don't know what the costs are today, but, in my experience, these things have tended to stay on par and even go down in cost because they become more commoditized. It's just, sorry, um, more and more, they're available to more and more people. Back in the 60s and 70s, it was really only the uber rich, the affluent, who would have these things. But nowadays, the average investor, this is it. This is right at your fingertips. So I think I would explore the use of a trust. Hey, Bishoy, if they're in, like, some other state like Georgia or Colorado or something, can they still reach out to you, or do you have a way to serve them even if they're in another state? I know you're licensed in Florida, but I'm just not sure how the
Yeah,
if you
I
can.
always tell people just reach out to me, and if it's something I can help with, I will. If it's not something I can help with, I'm getting very good at saying no, which was always a weakness of mine in the past. But I'm good at saying I can't do that or I won't do that.
Mm.
A lot of times it's something that I have clients all over the country and really all over the world, and so a lot of times I could help them kind of inside, but there are certain things, of course, I can only do in the states that I'm licensed in. I only practice in Florida. I have my New York license. I only practice here. So anything in Florida for sure we could do. Anything outside of that, I may be able to advise you, guide you, or at least make a connection for you. So it doesn't hurt to ask. I'm always happy to help how I can.
Okay. And I got one more question for you. Guys, if you have questions, you better get them in quick. But Bishoy, would you mind? I've mentioned a few times to these guys you're working on a book. Um, any like is this something we're going to be able to get on Amazon, or can you give us a little intel on that? Maybe a sneak preview. We'll be your first testimonials.
Yeah, I started writing a land trust book earlier this year, a book on land trust, and I kind of stopped because I got so busy. So Gary kind of has been encouraging me to get back on track with it. So I need to. It's mostly written, but I haven't done anything on it in a few months. So I got to get back on track. Um, but yeah, it's going to be about land trust. It's going to be all about the stuff we talked about today. It's something that I'm passionate about because I feel like it's a completely underutilized tool. And what I'm very kind of blown away by is just how little people know about land trust. It's kind of like this mythical creature, and people are like, is it true that this, and is it true that that, and a lot of times, it's just education. And once people understand and they ask the questions and they kind of break down those barriers, it becomes a no-brainer for people. So I've kind of made it my mission to go out there and educate the public on it, because a lot of people are guarding the secrets, right? And my goal is to educate the public on them and not just keep it confined to the super wealthy celebrities, rich, politicians, like you said, Gary, all that stuff.
Yeah. Okay, guys, going once, going twice, and Bishoy, you're welcome to stay on, man, if you want. I generally stay on a few minutes extra for people. Like I know Bonetta's got some questions, not on tonight's subject, but other things. I usually do that. Um, and if you've got to go, we definitely thank you for your time. This was a this was a great gift for us that you did, and I know you're busy. Um, so thank you from the bottom of my heart. If you guys wouldn't mind, give Bishoy a big pat on the back or a hand raise or mute yourself or put it in the
Thank you.
chat box.
Virtual
Yeah,
round of applause. Yeah, thank you.
there you go. Well, here's the funny thing is, joking, all joking aside, when do you ever get a chance to talk to an attorney face to face and not get billed? So you just got an hour and a half times close to 30 people. That's pretty awesome.
I
So I
know.
owe you one, Bishoy.
Oh, it's no problem. It's no problem. Um, Yeah, I think Henry's asking me if I do New York. So I don't practice in New York. I have my license. I used to practice up there. I refer stuff to my old firm up there. I'm very good friends with the attorneys up there. She does New York, Pennsylvania, and New Jersey. So anybody in the tri-state area, I can definitely give you a good referral up there. And so, but yeah, I don't practice in New York. It's just so different. It's a dog eat dog world up there, and I left 10 years before everybody else did, or maybe about 8 years before everyone else did during COVID. So I saw the writing on the wall, and I moved to Florida. So yeah.
Yeah. Well, everybody write
But
down Bishoy's email, and then Bishoy, this will all be in the show notes too that goes out. I'm sorry, not keep thinking of podcast. In the after class email that Sugar sends out tomorrow, it'll
yeah,
have your email in there, and it
yeah,
and the
email, social media, email, either way you can get a hold of me, and those are the best two ways. You could DM me on Instagram, you can email me, and then I'm trying to get my YouTube channel up and running, so give me a follow there. But yeah, I mean, I'm happy to help however I can. You know that.
okay. Well, tell you what, with the YouTube channel, um, let's stay in touch. I obviously big on it, but a couple of our agents are doing quite well, growing their following even faster than I am. It's crazy. So we're happy to return the favor and share what we learned about that.
Love to.
So
I just hired a new YouTube guy this week. I just got my setup tight, like as you could see, got the camera and the lighting right. So we'll be pumping out some content here about all kinds of cool topics. Land trust being one of them, but all kinds of stuff with commercial real estate, lending stuff, trends, BOI stuff. So we'll be talking about some cool stuff.
okay, awesome. Well, thank you, sir.
Thanks for having me. I really appreciate everyone's time on a Monday night. So thank you guys very much.
Thank you.
You got it. Thank you.
Take care.
You too.
Bye.
So if you have questions, guys, Bonetta, I think you had a uh, post. You had some questions. Bonetta's still here. There she is. Hey, Bonetta. I'm gonna click ask to unmute. She may have stepped away.
I'm here.
Well, there you are.
I was trying to unmute myself. Yeah, I have a question about my property that I was
Okay.
talking. That's what I want to talk about. I don't know if you have time now, later. That's my big deal.
Yeah. Well, it's up to you. We can either do it, close out the meeting and do it one-on-one. If it's,
Is
is
there
this something
anybody
that
on
could be
here
a
that
learning?
does commercial? Is there anybody on here that does commercial?
Yeah, absolutely.
But I don't
Yep.
know if they're in my area because are they in? I'm looking for somebody in my area.
I don't see anybody on it from Northern Virginia here, but you got people on like, Lisa, Eric, a number of people have done, including me, done commercial. And I've done
Dutch
commercial in
isn't
Virginia.
far from you, Vanetta, but he's traveling right now. So
Who is that?
Dutch Andrews.
Dutch.
Yeah, I'm looking for
You need a local agent for something local, then it sounds like not a
no.
uh,
That's for my big deal that I was talking to you about.
okay.
So let's just talk offline. I mean,
Okay.
let's just talk offline. Because I want to run some things by you and some
Okay.
ideas. All right. Do you have time tonight or because I
Yeah,
can't wait till
as soon as you-
December.
Yes.
Just as soon as
As soon as we
I
wrap
saw
up,
your calendar, I can't wait till December. That's why
Yeah.
I sent you a text earlier, but I don't know if you got it.
Oh, I don't think I saw that, but I'll call you as soon as we wrap this up and at it, because I know tomorrow I'm looking at it. It's pretty busy, and of
Okay.
course nobody's gonna be working on Thursdays, so Wednesdays. I'll just go ahead and call you once we wrap this up.
That'd be great. Hi guys.
Yep.
Bye guys. Good seeing you. Happy Thanksgiving to all of you.
Yeah. Happy Thanksgiving, everyone.
Thank you for watching this episode of Monday Night Live. Be sure to subscribe to our channel and go to realestatewithgarywilson.com to join our community and start building wealth today.